We've got a genuinely fascinating legal battle to unpack. We're looking at a landmark 2024 Supreme Court decision, Bison Management Corporation versus AAA and Dale P. Perenito, GR No. 256540. It's an absolutely crucial case for anyone interested in overseas labor rights, corporate accountability, and honestly, just seeing exactly how far across the globe the protective arm of the law can actually reach.
Now here is the central mystery we're tackling today. Think about it. If a Filipino worker signs an employment contract right there in the Philippines, but then gets on a plane and flies thousands of miles away to work under a totally different government, do Philippine labor laws still protect them? To figure that out, we're going to look at the real-world story of two workers who faced sudden and really questionable dismissals abroad.
Setting the stage, we have Section 1, 2 workers, 1 agency.
Let's meet our dual protagonists. We have Dale Perenito and another worker whose identity is protected in the court records, so we'll just call him AA. Both of these guys were hired by Bison Management Corporation. They signed standard 2-year contracts to work over in Saudi Arabia, passed all their rigorous medical exams, and deployed to earn a living. But, as you might guess, neither of them actually got to finish those 2-year terms. Their livelihoods were just abruptly cut short.
This brings us to Section 2, Perenito. Fired over a break? So Perenito had only been on the job in Saudi Arabia for about 9 months before he was suddenly sent back to the Philippines. And the stories of why he left could not be more different. Bison Management went to the labor tribunals and claimed, hey, he voluntarily resigned because he wanted to transfer to another employer. But Perenito, he vehemently denied that. His reality was that he was terminated simply because his employer caught him and his coworkers having a conversation during their break time.
Now, to prove this supposed resignation, Bison Management submitted an email from the foreign employer. And get this, the email just says, "I would like to inform you that there is nothing going on from what you were saying." That's it. It was completely undated, had no basic details about the sender or the exact recipient, and zero clear context. Bison somehow tried to pass this off as solid proof of voluntary resignation.
But the Supreme Court saw right through it. In fact, it completely backfired. The court pointed out that saying nothing going on from what you are saying obviously implies the agency had reached out to ask about a problem. So rather than proving a resignation, this vague email actually backed up Perenito's story. He and his coworkers had been actively complaining to the agency about being forced into exhausting 12-hour workdays. The legal burden of proof to show a resignation is voluntary is always on the employer. And well, Bison completely failed to meet it.
Let's shift gears to Section 3, AAA, dismissed for HIV status. This is a highly sensitive and completely different type of dismissal. AA had been working over in Saudi Arabia for over a year when he acquired HIV, and because of this, his employer abruptly fired him. Obviously, this is a devastating situation involving health, privacy, and job security. And when AA filed an illegal dismissal claim in the Philippines, Bison Management tried to use a foreign country's laws to shield themselves.
Bison's defense was basically this. They pointed to an agreement on labor cooperation between the Philippines and Saudi Arabia, claiming Saudi law strictly prohibits foreign workers who test positive for HIV. But here is the critical reality check. The records clearly showed AAA deployed with a completely clean bill of health. He passed all those mandatory medical exams prior to leaving the Philippines, which means the illness was acquired during his employment overseas.
Which perfectly sets up the big legal question in Section 4. Which country's law applies? The Supreme Court pulled out a really fundamental legal doctrine here called Lex Loci Contractus. It's a fancy Latin term, but it simply means the law of the place where the contract was made. Because AA and Perenito physically signed their employment contracts in the Philippines before they got on that plane, Philippine labor laws are the default rules for their employment. You don't just lose your Philippine constitutional protections the second you cross international borders. Now, there is a tiny exception to this, but it's a really strict test. If a company wants to use a foreign law to justify firing an overseas Filipino worker, they have to jump through 2 big hoops. Step 1, they absolutely must legally prove the foreign law exists by bringing official, authenticated copies to court. And Step 2, they have to prove that this foreign law doesn't go against Philippine public policy, morals, or good customs.
So, did they pass the test? Let's look at Section 5, the processual presumption.
Spoiler alert, Bison Management completely failed Step 1. They did not present an actual authenticated copy of this supposed Saudi Arabian law. You know what they submitted instead? An internet news clipping? A headline that literally just said,
KSA envoys seek stricter HIV/AIDS test for OFWs. You simply cannot walk into a legal proceeding and claim a foreign law exists because you read an article about it on the internet. It has to be legally authenticated.
And because they dropped the ball on proving the foreign law, this amazing legal concept activated. It's called the processual presumption. Basically, if you claim a foreign law applies, but you can't actually prove what it says in court, the Philippine court is just going to assume that the foreign law is exactly the same as Philippine law. And under Philippine law, firing someone solely because of an acquired illness is heavily restricted.
The National Labor Relations Commission summed it up perfectly, noting that while the agency harped on the alleged policy, they failed to adduce competent evidence to support their claim. Without hard evidence, the defense completely crumbled. The Supreme Court even added that, hey, even if you had proven the foreign law existed, if it lacks compassion and contradicts Philippine public policy regarding worker protection, Philippine law is still going to override it anyway.
And that brings us to the grand finale, Section 6, the Supreme Court's verdict.
The Supreme Court totally affirmed the lower court's rulings, scoring a massive victory for OFW rights. The absolute core of this decision is captured right here. Employees are not stripped of their security of tenure when they move to work in a different jurisdiction. This is such an empowering mandate. It proves that the constitutional right to humane working conditions travels right alongside Filipino citizens no matter where they are deployed globally.
And the court made sure justice wasn't just theoretical. They held the agency and the foreign employer jointly and severally liable, awarding some really comprehensive damages. Both Pernito and AAA got their unpaid salaries, plus the salaries for the rest of their unfinished contracts. They got vacation leave pay for 42 days, plus 50,000 pesos in moral damages each, another 50,000 in exemplary damages each, and 10% for attorney's fees. It brought total, complete finality to this dispute.
This case is a stark reminder that your employment contract matters, and the place where you sign it matters even more. So I want to leave you with this to think about. As our global workforce just keeps expanding and borders become more fluid, how will strong national labor protections like the ones we just broke down today shape the future of international employment? Are we going to see more countries stepping up to legally shield their citizens abroad? It's a huge question for the future. Thank you so much for joining me on this explainer, and keep asking the big questions.